All right, joining me to discuss this hour, Deputy Chief of Investigations for Gwinnett County, Georgia, Curtis Clemens is here in studio, and criminal defense attorney and former prosecutor David Bruno joins us as well. Gentlemen, thank you so much for joining me here on the program. Completely appreciate it. David, I'm going to start with you because you've got experience on both sides there as prosecutor and defense attorney. You saw the prosecution there. It kind of, the tables were turned a little bit. Usually it's defense saying, hey, the prosecution's not turning over what they need to turn over. Today it was the prosecution claiming that the defense gave them things. They needed more. There was audio, as we just heard. Apparently there wasn't any audio on a reenactment, but that's what jumped out at me. It seems like the defense has created a video reenacting the crime because, as we know, right now, based on her explanation on the phone as to what happened, doesn't really match up with the forensic evidence.
Yeah, for sure, Michael. I mean, to your point, I mean, normally it's a one-way street. The prosecutor's got all of the requirements for discovery, exculpatory discovery, inculpatory discovery, and the defense is really limited as to what they're going to use and statements that they're going to use and witnesses they're going to call. But here, like you said, they apparently have this reenactment. And number one question is going to be admissibility. I mean, whether or not it's admissible or it's speculation or net opinion, that's going to be number one. But before they even deal with that, the prosecutor is right to want to talk to everybody that had a part in that. Now, if the defense is going to use it, then sure, there may be some statements that are made in the production. And by the way, the defense attorney said he was present. Man, that's not a very good look for defense attorneys when you're a part of the making and the production of discovery like that. And he better watch what happens moving forward, because if he had a part, any statements that he made to any witnesses, potentially this prosecutor, if they're aggressive enough, could try to get information about what the defense attorney said to these witnesses. Yeah, no doubt about it. He put himself into the trial. He could end up being a witness in this case. You want to stay away from those things for sure. All right, let's bring back in our guest, Deputy Chief of Investigations for Gwinnett County, Georgia, Curtis Clemens, and criminal defense attorney, former prosecutor David Bruno. You know what's interesting, David? There was, in the motion filed by the state, they mentioned that there has been plea negotiations. They were turned down by the defense, mostly because the one thing they wanted her to plead to, and they were saying they would make it much easier for her, they didn't give the exact terms, but they said she needed to admit that she was responsible for bringing the live ammo on the set. Why is that so important to their case? Well, I mean, it's important to show her responsibility. And again, that really doesn't make its way to Alec Baldwin. I mean, I've always had a problem with the case and the prosecutions. Round and round we go. It's the dismissal and the indictment. We're back here. And to answer your first question, Michael, it absolutely gets better for Alec as we continue to point the finger at Gutierrez Reed. Now, prosecutors, they may think that she'll be helpful to the case if she's a cooperator. And that may be true. Who knows what she would have said, but that's not happening. It looks like that train has left. The defense is saying that this guy, Seth Kenney, who is her mentor, has some responsibility in the live rounds, and that he should have been looked at, and that prosecutors turned a blind eye to Seth Kenney. Now look at the way that this is going, right? It's not about Baldwin now. Gutierrez Reed is actually trying to point the finger at Seth Kenney. And who knows, but as we continue to talk about Gutierrez Reed, it gets better for Baldwin, because Baldwin's going to say, hey, I just got there. I assumed the armorer had a safe operation of the gun with dummy bullets, and that's why I did what he did. But we're in a criminal court. It's proof beyond a reasonable doubt. Even though this is criminal negligence, which is an odd word in the criminal justice system, it's still proof beyond a reasonable doubt. It'll be interesting to see how this all develops. Yeah, no doubt about it.